What is the implied consent law in New Jersey? Driving in New Jersey isn't just about following traffic lights and speed limits. The moment someone gets behind the wheel, they automatically agree to a set of legal obligations, one of which is the state's implied consent law. This law plays a major role in how DUI stops are handled and what happens if a driver refuses testing. New Jersey drivers need to understand the stakes. Refusing a breath test when requested by law enforcement can lead to penalties as severe as those for a DUI conviction. If you're navigating a charge like this, swift legal guidance is key. Law and legalities of implied consent in New Jersey. The implied consent law is written into NJSA 39-450.2. It states that anyone operating a vehicle on public roads in the state is deemed to have given consent to a breath test if suspected of driving under the influence. Law enforcement must have probable cause and must inform drivers of the consequences of refusal. Penalties for refusal are steep. A first offense can lead to license suspension for 9 months, along with a fine of up to $500. A second offense may trigger a 2-year suspension, while a third carries up to an 8-year suspension and a $1,000 fine. These consequences are in addition to any penalties from an associated DUI conviction. What is the implied consent law in New Jersey? It's a legal doctrine that applies to every driver in the state. By driving on New Jersey roads, a person automatically agrees to submit to chemical testing, like breath or blood tests, if arrested on suspicion of DUI. This isn't something drivers sign or say, it's built into the privilege of holding a driver's license. Refusing to comply doesn't exempt someone from consequences. In fact, refusal can lead to its own charge, separate from a DUI, with license suspension and monetary penalties. For underage drivers, the law is even stricter. Those under 21 with a blood alcohol level as low as 0.01% can face DUI charges, and refusal triggers the same penalties as adult offenders. The process and scope of implied consent is triggered the moment someone starts driving. Even if the car isn't moving, say, parked with the engine running, law enforcement may consider implied consent in effect. If an officer has probable cause to make a DUI stop, the driver must comply with a chemical test. Refusal doesn't always mean saying no. It could also include not giving a proper breath sample, staying silent, or even asking to speak to a lawyer before testing, none of which delay the process legally. Drivers don't have the right to consult an attorney before taking the test, and demanding to do so can be considered refusal. However, the law isn't without limits. Officers must follow specific procedures and inform drivers of the exact consequences. If they don't, or if there's a language barrier or medical issue preventing compliance, a skilled attorney can raise a defense. This is where having a knowledgeable law firm on your side makes a significant difference. If a driver is convicted of refusal, it stays on their record and may affect employment opportunities, especially in jobs that involve driving. A lawyer can evaluate every step of the traffic stop and testing to identify procedural missteps that could make or break the case. If you're facing charges under this law, legal support can be the difference between a suspended license and a strong defense. For tailored guidance and a strategic approach, contact the Kugel Law Firm at 973-854-0098 or visit us at 1 Gateway Center No. 2600, Newark, New Jersey, 07102, United States.